Welcome and good evening, my live video. Today I'll speak about non-molestation order or occupation order. So how you can defend non-molestation or occupation order. Otherwise, how to set aside non-molestation or occupation order. So this is basically non-molestation and occupation order is basically some form of injunction against a so-called abusive spouse or a family member. Now, most of the cases is normally a husband or wife seek an injunction to the family court against the other partner, which is basically called grant an order called non-molestation order or occupation order. So in this video, I'll speak about how you can challenge the non-molestation or occupation order, or how you can set aside the non-molestation order. Generally, non-molestation order or occupation order grant without notice most of the cases against the other parents. Now, if it is, but if it is on notice, then you can stay to attend the hearing before the court, and then you can explain your position. But if it is granted on without notice, then you don't have any knowledge about it. So let me give some introduction of the procedure. First, the other party, the victim will apply for non-molestation order without notice. So court will grant within 48 hours an injunction, as well as most of the cases occupation order against the other party. Now you have to be very careful. Once you receive the court order through the bailiff or any other means, as soon as get it, you have to be very careful. You need to comply with the court order, other will be contempt of court and offense. You will be arrested by the police, so on. But if you don't receive the court order, you are in safe. So once the court grant the court order without notice in your absence, then the court will give another date, which is maybe after 2 weeks. You will appear to the court, and then you can give your position to the court. So at the time, in the defense, non-molestation and occupation order, I'll give you all the point how you can defend. But before that, let me tell you the other form of injunction. So that's secondly, the injunction which was granted without notice, and the second hearing. So, for example, you haven't received the court order, so you don't know. There will be another date where you're supposed to attend the hearing as according to the notice, and you haven't received the court order, so you don't know. You fail to attend the second hearing as well, and the court grant an order for whole 1 year, and you are in a point where you need to set aside or set aside, because you set aside a court order, because this, say for example, the non-molestation order or occupation order, what was obtained based on fraudulent grounds, or based on the allegation which is not correct. So you need to apply for set aside. So what you need to do first, you need to make an application immediately without breaching the court order to the court, and you need to fill up application form, which I'll show you in the screen, which is basically FL03. And this is the form what you need to this is the application form. Let me show you the whole screen. This is the application form you need to complete. So this is basically the case number, date, your name and address, contact details, the other party name and address, contact detail, and either you can give the reason why inside this form why you want to set aside or defend this non-molestation order, the grounds, or you can give a separate statement. Generally, we provide a separate statement, point by point, allegation by allegation. So you need to click here, sign here, date, and your full name, address, and then you can submit it. So this is the form where you need to submit to the court. But the statement is very important, because the merit of your application, whether court will grant your set aside application, will depend on your statement, and the merit of your statement, and how true your statement is. Because Now, in that statement, basically, I'll show you in a separate video how to draft a witness statement for any family proceedings. But basically, you need to give the court headings, the case headings, so your name, court case number, court name, party name, and then your statement. Then my name is so and so, of my address. I'll say as follow, and then you tell the background. You need to tell how your relationship it was, whether any family children involved in this family, and then the allegation what your other partner raised in her application, in her statement. You need to go one by one to respond each and every paragraph of allegation. So allegation number one, or paragraph number one, my wife say or my husband says so and so, which is true or not true, or if it is not true or true, on what circumstance it has happened. So this is, you need to give response of every single allegation, and then you can give your prayer whether you want to cancel, set aside, or bury. Okay, so this is the statement you need to draft, and then you can submit it to the court. Court fee, I think 200, probably 40. You can send it by post or email. Also, you can submit online. So this is the application is submitted. Once it's done, then more likely, and also you need to send a copy to your to the applicant. I mean, to your other partner who applied for non-molestation or occupation order. So this is the procedure. Now, once you serve it, then court will receive the application. Court will more likely give a hearing date. Now, in the hearing date, this is the point where you need to settle this, the order, where you need to defend it. Now, more likely, what we do, if we see there is some allegation which is basically is correct, and there is some evidence, supporting evidence for the allegation what your other partner made, and the fact will be proven anyway in the court. In that case, more likely we'll go to an undertaking, means we'll give an undertaking to the court that will not happen, and then what will the court will we do the court will basically cancel the non-molestation or occupation order. Now, you can also make counter allegation against your wife or against your husband if you have any allegation against her. Then what will happen if you go through the undertaking? Then we'll do a cross undertaking. So you'll give an undertaking, you will not molest her, and she will give the same undertaking. So that will give you both in a good position, equal footing. So that is the best option. In case if they do not agree, the party, say for example, your wife doesn't agree or your husband doesn't agree for undertaking, then the court will court will more like give a direction first, and then court will fix it for fact-finding hearing, whether fact-finding hearing basically what the allegation you made is true or false. So this is the final contested hearing, where court will give direction. You will give your evidence, provide all the supporting statement, evidence, everything. The both party will submit it. Court to, if it is reported to the police, court will more likely give direction to the police as well to release their record to the court. If you want to put any other witness, you can ask the court as well, and you need permission from the court to provide any witness statement. So this is how the non-molestation order you can defend. And then final hearing, court you'll go to the court, your solicitor, or you need to submit the bundle. Normally applicant responsibility to submit the bundle. So you need to provide your supporting evidence, application form, your statement, as well as your wife's supporting evidence statement, whatever their lawyer or she will send you directly, and you need to put one document and send it to the court, one copy, the bundle, and one copy you need to send it to your other partner, the applicant or respondent. Now, what is important here, when you go to the court, so first, if you have a lawyer, so your lawyer will open the case, and then you will give evidence. More at the beginning, judge will give some introduction, and then your lawyer, if you are the applicant, your lawyer will start the case. Then he will ask about the statement, whether it's your signature, whether this is your witness statement, what you want to tell the court orally. And then if any clarification needed on the statement, your lawyer will ask you a question. And then there will be a cross-examination, which is basically the other party lawyer will ask a question, technical question, leading question to make you false that the allegation what you made is not correct. So this is how exactly we'll do that with the respondent, with the other party, your wife or husband as well. Once that has been done, in the meantime, judge will interfere sometime with the question. A judge may ask question to understand it anytime when is required. Finally, once it's all done, then judge will make a decision. More likely, judge will take a adjourn hearing for a couple of minutes, and then will come and give the judgment. Which is this is how the non-molestation order procedure work. So if you are in a position where a non-molestation or occupation order granted against you, you can apply to set aside or vary, which is undertaken, for example, or defense the whole application in the court legally. So this is a brief introduction. It's not a legal advice. If you are in a situation of where you need advice or need help, please feel free to contact us. My name is Suhail Ahmed. I'm the principal solicitor of SWF Solicitor. We have office in Milton Keynes, London, but we give advice through the whole UK, and we attend the hearing in different courts as well, everywhere in the UK. So if you need any help, please feel free to initial consultation. My contact details is appear on the bottom of the screen. We do Zoom and video meeting if our client can travel to our office, just for the convenience of our client. So thank you very much, all of you. This is for today. I hope that information will help if you are in that situation.